This is News Hour, and let's now get into the conversation. Thank you very much for being part of the bulletin and the conversation, which essentially is touching on every other person represented in the National Assembly, where, of course, we believe the majority have their way and the minority their say. We have the legal voice in studio, but just to give you a background, the Speaker of the National Assembly, Moses Wetangula, upheld UDA-led Kenya Kwanza as the House majority today. In his ruling on the implications of the court decision on House proceedings, the Speaker cited post-election arguments filed with the Registrar of Political Parties as a key factor in determining the majority status. However, there are still analysts who are saying there could be other ramifications politically and legally. Nelson Harvey, who is an advocate of the High Court and the 49th president of LSK, has created time to be here tonight. Wakili, good evening.
Good evening, Ombat. Thank you for the welcome.
What would be your opening remarks, especially after the happenings yesterday and today in the National Assembly?
Well, as expected, the Speaker of the National Assembly, Moses Wetangula, has disobeyed a court order. And to what extent we say that he has disobeyed a court order? The decision by the bench of 3 judges was quite clear that the Speaker of the National Assembly does not have the power to determine who is the majority in the National Assembly. And what does he do? He proceeds to do the same. I mean, this is the level of failure of good governance that there is in the legislature as we speak.
Now, that same confusion is getting into a lot of Kenyans' minds right now, because you say this is what the judge has said. The Speaker says he has the power to actually declare who is the majority as guided by, according to other members of parliament, the parliamentary practices, some of which we would hope that the legislator who will be joining us shortly, Millie Odhiambo, will give us some insight into. But let's begin with, what is this court order that Wakili and I here and the rest of those concerned are referring to that was pronounced last week? Listen in.
In the process declaring Kenya Kwanza the majority party in the National Assembly, the Speaker acted arbitrarily and violated Article 108 of the Constitution. The Speaker had no basis to disregard and dismiss the Registrar of Political Parties information on the membership of Azimio Coalition and Kenya Kwanza Coalition.
Just a glimpse of it. Wakili, this is in public domain, really, and different reactions coming through. But so far, there are this feedback that has come in, and Kenyans are saying, essentially, the Speaker has defended his position. Looking at the report and documents with the Registrar of Political Parties, looking at how many parties moved and shifted allegiance from the Azimio coalition, if I just look at the reference coalition agreements that he actually spoke on from the Registrar, which indicated 14 members of parliament from 5 political parties had exited Azimio la Umoja, thereby denying the opposition coalition their majority status it sought. These are not heavy enough to then still have these numbers unchanged and the status quo remain?
But the process through which disputes are resolved in court is not intended to enable the person who has flouted the law to go back and remedy his or her error and come back and say, notwithstanding what the court has determined as unlawful on my part, I've gone back and done the same thing, but in a different, better way. Simply put, the hammer or the knife of the rule of law cuts and leaves an indelible mark. To this extent, therefore, upon the pronouncement by the court, in respect of 2 things. 1, the power of the Speaker, and 2, the extent of the majority or minority, the matter rested there. It was not a referral back to the Speaker to determine the issue in his mind, based upon the same evidence that he had much earlier, which has not changed.
So what you're saying, because even if you listen to the speaker today, he continued to reiterate that he was working within the law. In fact, after the standing order of Lily Odhiambo, Suba North, a member of parliament, and after she said that Azimio respectfully disagrees, he said in his conclusion remarks to the next session that the law is the law. The speaker himself is attributing what he's doing to the law.
No, I mean, everybody knows between Moses Wetangula and Nelson Harvey.
All right.
It is Nelson Harvey who speaks the correct position of the law. And I say this not out of chest thumping, but out of the express reading, first, of the Constitution itself, and the judge quoted Article 108,
yes,
which is quite clear. The determination as to who is the majority or minority in the House is made upon gazettement by the IBC of the number of members of National Assembly that have been elected. It doesn't require further adjudication by the Speaker. So insofar as the court clarified that position, the Speaker could not again go and seek to adjudicate, in his view, on the basis of information now claimed to have been received from the Registrar of Political Parties. But why did Moses Wetangula act in this particular manner? There is a fundamental aspect of the decision by the three-judge bench that must never be ignored. Moses Wetangula is biased. I will go to the extent of saying he is uninformed and unconscious of the mood of the people of Kenya, let alone the mood of the House at the moment.
Let me just quote what the Speaker said, Nelson Harvey. He said, as Speaker, I do not debate, I do not vote, I hold a position of honor to preside over the proceedings. Let me just hear by the National Assembly Speaker on his impartiality and also just his verdict this very day at the National Assembly.
Law, sometimes you may step on somebody, sometimes you may not. But the law remains the law, and in the law we trust, in our constitution we trust.
Let's talk about his impartiality. You know, you said that the Speaker ceased to hold that office immediately after the court pronounced himself. We're talking about him being a Speaker and also the leader of Ford Kenya. And this is where he responded. He said, as a Speaker, I do not debate, I do not vote, I hold a position of honor to preside over your proceedings, end of quote. So when you argue this way, what exactly does the law then say in the position of Speaker Wetangula?
Yeah, let's just break it down.
Yes.
Moses Wetangula is the party leader of Ford Kenya.
Right.
Ford Kenya entered into a coalition agreement with the UDA and ANC. Now, part of that agreement was that he will be the designated Speaker of the National Assembly. Speaker of a National Assembly is a public officer. He holds a state office created by the Constitution. Now, the manner of exercise of the power of the Speaker is determined by the Constitution. The eligibility for one to be elected Speaker and continue serving as Speaker is determined by the Political Parties Act, the Leadership and Integrity Act. It removes him from the political arena by saying he should not continue holding the office of party leader of Ford Kenya. But he has continued to hold this office for a period of over 3 years. And it's for that reason that I said the court cannot dispossess him of his office as party leader of Ford Kenya, because the issue was not before the court in the first instance. And secondly, the issue is one that is to be determined under Article 38 of the Constitution. It is his right to be a leader of a political party. But the moment he has taken that right, then he is disqualified from becoming a state officer in the office of Speaker of the National Assembly. So what he ought to have done was to cede the office of Speaker, the office of the party leader of Ford Kenya. And having refused to cede that office, then he is disqualified from holding the office of Speaker of the National Assembly. And it's for that reason, therefore, that I believe there is talk amongst several members of the National Assembly that his conduct not only amounts to a violation of the Constitution, but is a ground upon which he may be removed from office. A position that is well merited and which ought to apply in this particular case.
Ought to apply.
Yes.
Now, whether it will apply or not, it's a wait-and-see situation, but this is what you're saying legally, this is what ought to apply.
Yes.
Now, let me just go into what the Speaker said as a way forward, because then Kenyans essentially looking at a House that should function. If you followed today the proceedings in the House, a section of the Azimio members of Parliament stormed out after the Speaker gave his verdict, especially after, Millie Odhiambo said that they respectfully disagree. So in that kind of mood, Kenyans are asking then, will this House work and keep the state in check? Now, the Speaker instructed that an appeal be launched against the judgment, saying he read it and it has been explained to him at length by the Parliament's, according to him, able legal team. Let's talk about that next step, the appeal. What are we looking at as far as the corridor of justice is concerned? What is this next stage if the appeal is actually taken forward with?
Two things. First, if the Speaker is of the view that the court order did not bar him from continuing his unlawful and unconstitutional action, why is he appealing it in the first place?
All right.
It is a confirmation that it has had an impact on his continued occupation of that office and the decision that has prevailed for the last 3 years on the issue of the majority and minority. That is the first aspect of it. The second aspect of it is this. We have demarcated with clarity political officers in a political party and public and state officers designated by the Constitution. We have seen under the Political Parties Act, there is a category of leaders that can maintain their membership to a political party as well as the office they hold in that political party. And these are the member, the MCA, member of National Assembly, the woman rep, the senator, the governor, the deputy president, and the president. And that delineation was intentional to ensure that there is objectivity, there is no biasness. The holder of the office of the Speaker of the National Assembly, he is the head of an arm of government. Yes, he does not participate in debates, but is supposed to moderate the debates, and where clarity of the law is required, supposed to give it. But how will he do this, yet he still holds the office of a political party, head of a political party? What is the prospects of success of an appeal from a decision that is so clear as we have indicated? My evaluation is it has a snowball chance in hell before the Court of Appeal. But again, we live in Kenya, where windows tend to be created out of walls instead of people passing through the door. It remains to be seen how the matter will be handled by the Court of Appeal.
And that, of course, we await to see. But look at this. According to what the Speaker said, and if Casey said, Wetangula says court did not give the direction, according to the Speaker, on which side is the majority or the minority? Is it?
No.
If you were to just dissect that ruling.
The court said this, that what is discerned from the Gazette published by the IBC is that the Azimio coalition had 171 members of National Assembly. Kenya Kwanza had 165. And that is self-evident. It doesn't require an adjudication. How many fingers do I have? There are 5 here, there are 5 here, there are 10.
Yeah.
Do we really need an adjudication as to the number of fingers I have? Unless, of course, there is a medical report that I have an extra finger here, or less than 2 fingers. That's what the court said in no uncertain terms. Yes, the court did not direct the Speaker of the National Assembly or the National Assembly on what to do.
All right.
The court annulled the irregular, unlawful, and unconstitutional action of the Speaker of the National Assembly, with the result that the status quo ante, what prevailed before they took the erroneous decision, will apply. And what was that? Azimio which had already seconded the name of the majority leader, will occupy the majority position. And so with the rest of the committees of the National Assembly.
Yeah, we're very, very intrigued by, how this took over the business of the House, yet there was a lot in the interim. But I still want to just dwell on that. The status quo. Seems like there is a bit of a confusion here. According to the Speaker, what remains unchanged is that Kenya Kwanza has 165 members, Azimio 154, which means Kenya Kwanza remains the majority. But someone would ask then, more than a year, 2 years thereabout, for the court to just come up with this verdict? Is it, someone actually said that this is justice denied for the Azimio coalition? Why would it take so long for the corridors of justice to clearly come up with a verdict on a matter as key as this?
Well, in the recent few months, we've championed a cause for accountability and integrity, and over and above those two, efficiency and service delivery by the judiciary. And I hope Martha Koome and Paul Demo are listening. Do not waste time coming tomorrow with a press statement. The decision by these three judges is a good decision, but it ought to have been delivered within a reasonable period of time. What is a reasonable period of time when you're dealing with constitutional matters, judicial review matters? It must be within 6 months from the time of filing. We are on our third year.
Right.
I mean, justice delayed is justice denied. So to that extent, that premise holds. But that does not negate the application of the Constitution, the application of the law, and the enforcement of this court order. It must be complied with.
It must be complied with.
Yes.
Now, what we're really going to ask is the impact that this would have, on this House. Yes. We're looking at, the reality is that there was a delay, really. What you're acknowledging is that there was a delay from the justice system, having said that they should have done this in a maximum, realistic time, of 6 months. Is it something that we need to look into? Allow us to take a very short breather, but we continue with this conversation, because what next remains the heart of it. Don't go too far away.